mention, please.
Yesterday, yesterday that government order was not available. I could not assist your lordships.
What government order?
This the section 5 application, the ground was taken. That
No, that I understand.
no, because I have searched, I got it. It is available in the headmaster manual.
Oh,
That's what. To show, madam, the statement is totally incorrect. I had a talk with Mr. Tale. He said, yes, I submitted. I could not find. But when you find, you submit the code. So it is not traceable. It is not available. That is wrong. Wrong statement was made.
May I be permitted to mention on matter, my lord, for leave to file an appeal without certificate, my lord.
when the order was passed, sir?
28, my lord, 28 January, my lord.
28th of January.
Yes, my lord. The application was made on 29.
29th. Have you annexed the server copy?
Yes, my lord.
Have you annexed the
Yes,
copy
yes,
of the
yes, ma'am.
application?
Yes, my lord.
Application for certificate copy?
Yes, my lord.
Have you annexed?
Yes, yes.
দেখে নিও যদি থাকে দিয়ে দাও
Yes,
তাহলে ছেড়ে দাও।
Memorandum appeal has been
Mention, my lord, item number 52. This is an application by appeal, my lord, by third party.
Correct.
My lord, I have filed the application for leave to appeal. This is appearing. My lord, I have also
Will be
filed the,
taken up.
No, I have also
কত থেকে
filed-
হবে আজকে
my lord, I am.
just wait হ্যাঁ কি আজকে 16 so just wait.
My lord, I have filed a stay application. This is can number 3. It may be, my lord, tagged.
First leave, cross the hurdle of leave, then cross the hurdle of section 5, then stay. Don't worry, just keep it.
It may be, my lord, it may be
First
required.
is the leave. Let us see.
Or there is urgency, that is why, my lord,
That
because
is what first the leave has to be granted. You are not a party to the proceeding.
yes.
But with leave of Honorable Justice Chatterjee, may I mention a matter before your lordship? But a full bench has been constituted, my lord, with your lordship, Honorable Justice Shampa Sarkar and Honorable Justice Hiramar Bhattacharya, my lord, to answer a reference, my lord. But the question of reference is, my lord, whether a bench not having determination to take up a matter, and if an order is passed, if the order is void or not. But
Don't
I am
know.
suffering it has been assignment on 26th of November, my lord. But I am suffering an injunction order.
my lord.
But the first serial number of the list, my lord. I
Memorandum
am
of
suffering an injunction order. If your lordships, my lord,
But the difficulty is nowadays because this Justice Sarkar is already there taking up the matter in the original side.
my lord. But any day, my lord, for
And-
15 minutes, if
and
your
the
lordships can
original
assist.
original side, the peoples have a lot of grievances that,
I understand,
that
but my
they
lord,
are hard pressed. So if we take them back, again it will aggravate.
the only difficulty, my lord, I am suffering an injunction from November,
what
my
can
lord.
be done, sir? At one go, you say that they are hard pressed. Don't please create another benches, and if we take her, then there will not be no matter.
But
So
my
just wait for it. Let us see. Let us see.
memorandum of appeal with application has been filed. Applicant is a minor. He's in class 9. He has been debarred from class since 5th December, last December 5th. And recently, very recently on the 8th, he has been issued a transfer certificate either mentioned.
Appeal, hearing. Just wait for a time. Have you seen this?
My lord, may I have your lordship's kind leave to mention a matter for an appeal to be included in the list, my lord?
Not. Wait for.
But not hearing matter.
Appeal, when you said that means an hearing.
No. My lord, it's the application, my lord,
That
stay application.
Stay application of.
My lord, on order passed by the single bench, my lord, where my repeat
I mean the group 2.
group 2, my lord.
I have your lordship's leave to mention a matter. Lordship, this is for rectification of an order. However,
Not passed by us.
no lordship. However, lordship, that determination is not sitting any longer. It's with Honorable Justice Madhuresh Prasad that was passed.
So we'll sit one day. They cannot.
My lord, we are the petitioner of FA 463 of 2003. It was pending from 2003 and it was my father has filed this case. He has died. We have been substituted. Now the opponent, he has taken the exhibited documents from the court.
Yesterday the matter was there, one application I believe. Yesterday there was one matter, similar situation, exhibited documents taken away, not filed. Yesterday, was it this matter? এই কালকে application একটা হচ্ছিল।
Baldev Singh, Bambodev Singh,
Brahmadev
Pradeep
Singh,
Singh.
this is that matter? No.
Asim Bose, and this was the order passed by the Logiba court, who has said to list the matter before the original bench.
এটা লজিমায় দিয়ে দাও। Will appear in logima. You have no lawyer,
So I have the lawyer.
then you can't mention. Give it back. Where is your lawyer? Either cancel the wakalatnama, is wakalatnama, appear in person, otherwise we will not forgive. That's the rule of the law. We cannot.
I am not a legal person. So
That's why I am saying, send your lawyer.
I am for the respondent number 7, Lordship.
Matter about matter.
Lordship, the appellant has been allotted one housing under PM Awas Yojana.
Correct.
He has constructed the house within the premises of unpartitioned.
How this matter, this is relating to that determination. Yes, it is relating to the other determination of Justice
Yes,
Chakraborty. Yes, yes.
The
Then?
petitioner, the appellant has constructed the house within the unpartitioned property of her father.
Partitioned the property.
Unpartitioned
Unpartitioned.
property of her father. Now, your lordship, the private respondents are claiming
The
that
co-sharer.
co-share. They are claiming that the property is, the housing has been constructed illegally, unauthorized construction. And obtained one order from the Honorable Justice Shompa Sarkar in document 4130, where she has ordered that the inquiry has to be made as such, whether it is illegal or not. Sir, in such an unfortunate incident, that advocate appearing for the appellant at that time did not appear in that matter.
Yes.
Now the order of inspection has been passed. The inspection has been made. In that inspection, the applicant has raised certain grievances that the property that has been constructed, it is constructed in the property plot number 869 and 871. The private respondents are saying that the property has been constructed in the plot number 870. The inspection has been made and the report of BLRO has been filed as that
The construction is at 870.
870 euros.
Correct.
Now the grievance is that, your lordship, there is no partition and she is not aware whether it is made on 870 or 869 or 871. The construction has been made under the supervision of Panchayat. He has constructed.
Have you taken any permission or a sanction before the construction is undertaken?
Yes, your lordship.
Had you taken any permission or a sanction before you take the construction, undertake the construction? On what plot of land the sanction or the permission was granted?
Lordship. Kindly turn to annexure T to your lordship, page number 26.
Madam, was it granted on plot number 870?
No, your lordship, she was not aware whether. That's not aware that it is applicant still not aware whether it is 70 or not.
You are the co-sharer,
The part of
whether it is a plot number, dark number 870 or a dark
your
number,
lordship,
something else.
your lordship, and it's
Give me
the
the-
lordship that has been partitioned, that has
Was
been.
there any amalgamation of all the entire plots?
Yes, your lordship.
Where is the order of amalgamation passed by the competent authority?
There is no order of amalgamation.
Correct. Under the West Bengal Land Reforms Act, when you are having a separate, each plot of land is a separate entity.
Yes, your lordship.
After the amendment having brought, if you may have been a co-sharer in respect of 50 plots. No difficulty. But if you make a construction after seeking a permission, then the permission must be given on a particular plot.
Your lordship, the plot is in question.
What plot is it?
Whether the construction has been actually
But
made
the
or
inspection says that it has been done on plot number 870.
that is why your lordship want a title suit has been filed in civil court for the partition and the demarcation of the plots.
Sir, this is a different one. Again, madam, when you include several tab numbers or several plot of lands into the partition suit, then the court will take care of that. But here is the question whether after taking permission or a sanction from a competent authority for construction of a structure on a particular plot, whether you have constructed on that plot or some other plot.
Yes, your lordship. In that regard, if your lordship kindly turn to page number 13, your lordship.
Sanction was
Notun
given
Kolkata,
on
Notun Kolkata.
868, but actual construction made on plot number 8.
So what can be done?
Your lordship, if your lordship kindly turn to page number 13, get partition deed. That partition has been made with the forefathers of the appellant, your lordship.
What?
That partition deed, the is evidence that 870 their clause. That is the
But the authority has found that you have constructed on a plot number 870.
yes, your lordship.
So how can you, if you are aggrieved, go and file an appeal against the order of the authority under the West Bengal Land Reforms Act?
Your lordship.
How we will do it?
No, the construction will be demolished, your lordship. Kindly get your.
Has to be, madam, you have to be very sure about it.
No,
What
whether
is-
the construction.
What is the post of Amin there in the department? What for the Amin is there? Demarcation of the plot, you can get it done through an Amin, whether this is the 870.
But your lordship, my only concern is your lordship, if your lordship kindly turn to page number 13, there is a sketch map given to the partition deed of the partition. deed.
Can a writ code go into this? The only thing is the construction, illegal construction has come. It is within the authority to take action. The authority has found that you have wrongly constructed. Then the law will take its own course.
But your lordship,
If you have a right, anybody problem, you can go and
there is an
avail the appellate provision or remedy, but we can't do it.
Your lordship, there is an ambiguity in the reports also. Your lordship,
So you challenge the report.
I
Did you
have
take
challenged
an
the report.
Did
I have-
you take an exception to the report?
I have
There is an order of the authority.
I have challenged that, your lordship.
68.
Page 68, Lordship. That is the order of the DM.
So the DM has also passed an order.
That challenging that order, your lordship, the imputed order has been passed. I have.
What? Challenging that order, imputed order?
Petition was
Order of this passed by district magistrate. I have filed the writ petition, your lordship.
Correct.
In that writ petition, your lordship, Honorable Justice Shankar Sharma passed an order asking if there is any civil claim, you go to civil court.
Correct.
Your lordship, I have gone to civil.
So get an
But-
injunction.
Your lordship, that if the
Get an
demolition
injunction.
state, your lordship, my civil case infructuous.
No, nothing infructuous. Your right under the Partition Act remain. Only thing the structure will go, but the right in the property would remain.
Your lordship,
If it is an illegal structure, even if
yes, your
it is the matter of subject matter of partition suit, but if it is an illegal construction, it is illegal.
Yes, I agree to that. Your lordship.
So when you agree, then demolish.
Your lordship, if
Demolition.
until partition is made, your lordship, it was
What
not-
are you talking about? This is the law. If we accept, it will be the greatest injustice one judge can do in the country. That a construction which is absolutely illegal shall not be demolished as a party have gone to the civil court filing a partition suit.
lordship, that.
I think my senior in the heavenly abode will be cursing me from there if he's watching me.
Your lordship, kindly hear me out. If that building is illegal, it will be demolished.
This is the illegal, madam. A sanction plan is or permission is granted to construct a house on a plot A. The house is constructed in plot B. Is it not illegal? Tell me then what is legal?
Your lordship, in
What
that-
is legal? Tell me.
your
What is the definition or a demarcation between legal and illegal?
Your Lordship, if I may, the sanction.
Tomorrow somebody may come, your neighbor, get a sanction plan for building. Your vacant plot is at the adjacent. He will come and construct the house at your vacant plot.
The
On
land,
your plot.
the land is not there.
I am
to
telling you,
construct.
on your plot, he will come and take the plea. Yes, I have got a permission. It can't be illegal. Let it be decided whether this right is there. I am claiming a right over that land. Civil suit will decide. Is it? Admittedly, when it is constructed on a different plot.
Your Lordship, the problem is that I have not admitted that it has been constructed in 870.
The judgment is staring at your face, and the authority who is the fact-finding authority, who is the fact-finding authority cannot.
That it is.
Sorry, we can't. No.
Sir, Your Lordship,
870 के declares that I am the owner and
Even if she is the owner of 870,
he can
870, but the permission was granted on 868. So it makes a difference.
Your Lordship, if I pray, Your Lordship, can you limit it even if there is any
Fine. That is a right, inchoate, inherent right, inheres in you. Why the court will give you that? If you have a right to go to civil court, you can go to the civil court. Why the leave of the court is required?
Because Your Lordship.
Only a blessing.
Not a blessing, not like that.
Definitely, you seek a blessing of the court so that you go and say before the civil court, look, this blessing has come from the High Court. And therefore, please protect me.
Not like that, Your Lordship.
It is what is latent, what is patent, what is latent is now being patent. What you say very innocuously, but the far-reaching consequences are very damaging. Sometimes the bad cases are to take risks. You have done your best, but
Grateful to your host.
Item 2 minute. Oh.
The preamble of the memorandum of deed does not indicate the name of the learned judge who passed the order.
My lord, may I take a point? Well, probably my lord has determination of urgent matters. If my lord is satisfied with the urgency of this matter, can he take it up?
I think this was pointed out to him yesterday.
What is the urgency? We are not there.
Why you are making this submission? You wanted to get away with this
No,
order.
no.
Then
My lord,
we are releasing the matter.
certainly not.
So
Certainly not.
you are so
I'll take it up.
apprehensive that this bench should not take up the matter.
I have
then
not
we are
said that. Only the urgent matters.
No, that
Is it
what-
urgent? If it is urgent, up to
when-
my lord's
when the
prerogative.
leave was granted after definitely taking into account the urgency.
I was not there, that's why. If your lordship satisfied, I have nothing to say.
Once you raise a question, then I take it that there is some
Urgency.
something,
Can I take it up? No problem.
something which impinges upon us to take up the matter.
No
playing
problem.
a havoc role in your mind. So it is better we are releasing this.
No. Kali, don't do that.
My learned friend says, my lord, your lordship can release so that.
No, Kali, don't do this.
And you say that it is not urgent, then we should not. take
No, that is my lord's prerogative, whether urgent or not. I have nothing to say. Urgency.
When
I
you
say if my lord
when
thinks
you
it is
say
urgent.
That means that you do not want this bench to take up this matter.
This is my lord's perception. I'm not my submission.
Yes, really. I do not want to. Amar Gram. Because my brother will be there.
This is unfortunate. I have not said that. I have said if my lord is satisfied urgency, I have nothing to say.
That is after hearing the appellate. But pointing
It
out
was not known to me.
connotes something else.
To my lord.
Yes. This will be for the chief.
May I only request
Immediately the order would
so
be
that I can-
signed within 11. Don't worry. No, sorry, 11.
No.
Within 12.
so that I can try my luck before him.
Great.
Item number 16.
College. Order.
Why you are true?
Judgments, you wanted to cite?
Yes. Judgment I am citing. My judgment I am citing in respect of the college.
No, I have recorded it. I am repeating. Mr. Bari, the learned advocate appearing for the respondent submits that such point has already been decided by the division bench of this court. Mr. Bari, listen.
Yes.
Decided by this division bench of this court in relation to a college matter. And therefore, the principles as laid down therein, is squarely applicable in the instant case as well. That's why.
Yes. এক্ষুনি আমি তো জেরক্স করি বুঝেছি কলেজ ম্যাটার
And you have brought the rules relating to college. And a distinguishing feature between the rules of college and the rules.
There is none insofar as college is concerned. There is none.
এটা জয়
That's only for recruitment.
Before that, the judgment which has been cited. ভাগ দিয়ে দিয়ে তো ওটা আবার না
নাম্বারটা হচ্ছে WPA
সাইটেশনটা বলবি সাইটেশন ইম্পোর্টেড এটা কি নাম
WPA 24,496
596 হতে হয়ে যাবে এটা সিএইচ না হয়েছে পাচ্ছি না বাকি তো হেডমাস্টার দিয়ে দাও দুটো আছে হ্যাঁ হ্যাঁ না হ্যাঁ ওইটা পাঠান দুটো তো বাকি হুম কথা থাকে আচ্ছা এটা ভিতরে দাগ দেয়নি এটা শুরু করে ট্রান্সফার উল্টো বল ট্রান্সফার উল্টো বল
ওদের কম্পাইলেশনের মধ্যে ট্রান্সফার করতে আছে কম্পাইলেশনের মধ্যে
ওই ছেলে অ্যাকাউন্ট তারপর বেশি না তো
বিমল বর্মনটা এটা তো
বিমল বর্মন ইজ বেশি বিমল বর্মন ইজ বেশি কত বিমল বর্মন হ্যাঁ ওইটাই অ্যাসোসিয়েটস তো এনেছি তো
জেরক্স করার মধ্যে এটা টেস্ট মাস্টার ফেস আছে আর দিশা
এটা এটা যেটা দিয়ে জিনিসপত্র চলবে হ্যাঁ
Yes.
It is the, always in the college, present the institute.
Not agree. Referring the
Now,
matter-
now my lord,
Referring the matter to another.
my second submission will be, with your lordship's my lord, this is. Attend.
That is purpose of constituting a service commission.
No, it is the, your lordship's consider.
What is said is very, very alarming. It says that there is, I think there appears to be some kind of a confusion in the mind while deciding this, the role of a state government and the role of a college authority. The state government who enacted the law, if the state government is an appointing authority, the state government may, for some reasons, can revert it to the commission over which he has a supremacy, some power of, or the control over it. Supreme Court in those line of judgments has said that the state government, but college authority is an important one. When the law says that no person can be appointed as a teacher or a non-teaching staff without the recommendation from the service commission. The college authority, what would happen? Do you know? One name came. College authority want the third person to be appointed, not the first. College authority will say, I am not agreeing, I am not going to appoint.
Exactly, it has happened.
I'm telling you, I am not going to appoint. Then what will happen? The entire process of selection that has to be scrapped.
Right.
If it is to be scrapped, new process, how long it will continue? Unless that third candidate is shown as first candidate. Law says that is only the first candidate in the order of, from ascending to descending order, you have to. If this proposition, I have the doubts, I have a full doubts whether it.
Yeah, my life lost the case before the trial court.
Recommending. They can't. They can place it, their objection. But ultimately, if the service commission says no, he's a meritorious person, the law was which has been taken is that where this civil judicial matter, where the selection was undertaken, 40 vacancies were notified. When the entire recommendation was done, the government issued the order of letter of appointment only to 7 candidates. The other candidates who were there in the line, they say that how can you deny the appointment? Because 40 vacancies were there and you have appointed 7. The government took a view that we wanted a high standard in the judicial system. So we have decided that the candidate who have obtained more than 55% of percent marks in the examination, they will be appointed. Because we can't compromise on the standard. After all, they are deciding the fate of the litigants of the country, which was the Supreme Court has said that yes, there is a justification. But that cannot be applied with such vigor and say the power to raise objection is there in unfettered right.
Anyhow, my lord, this was the judgment
Supreme Court was judgment. Appointment letter was submitted. Standard others were saying this.
That case, my lord, I lost it before the trial court and the division bench also affirmed the order of the trial court. Anyhow, my lord, my second limb of submission will be.
Who are nobody, you, I mean, you means authority.
No.
Merely for a namesake.
Being an statutory body,
No power.
No power.
But the school can say, sorry, I will not appoint,
Board cannot
but you
issue,
are recommended.
board cannot give
Will say
hearing,
so.
board cannot do anything.
What?
Submission, my lord, you have no power.
It is a school who has the unlimited powers, unfettered powers.
And board cannot control the schools. Cannot do anything.
Board or short board, body can do nothing. Can do service, can do nothing. Less tiger.
Less tiger.
এক্ষুনি দিলে পড়ে গেল নাকি কোথায় এক্ষুনি কারণে এর কাছে আছে বাস এটা কি একটা আছে কথা আমরা উপরে দিয়েছি কিছু হতে পারে ওই জন্য নিচে রাখা আছে হ্যাঁ নিচে রাখা দিয়েছি আমি process would be done. মাস্টার ব্যাটা বেরিয়ে ঘরে বিমল করবো তারপরে আর কি আছে কোনটা দেখা সমাধান আছে আর এটা আছে মানে বাড়ি তো এর ব্যাপারে নাই লোক আছে যেটা 3 and 4
So you are an expert of this branch.
No, but
look how gradually
this is my client.
How gradually the law developed. Initially, it was an unbridled, uncontrollable power of the managing committee of the school in relation to a management, administration, appointment.
Everything.
Then subsequently, some amendments have been brought into West Bengal's Education Act, secondary or higher secondary or what. And then 1997, the School Service Commission. Now, gradually, power of the managing committee was gradually curtailed and subsequently taken away. I think last amendment talks about the appointment letter to be approved by the board. Issued by the board.
Disciplinary control vested with the board.
2018.
It is only that the resolution will permit the joining of this teacher. Nothing more than that. He cannot say that I will not permit you to join. If everything has gradually gone beyond the hand, I believe
2017.
the judgment appears to be very harsh word I'm using. It does not appear to me a palatable one.
Hello, whatever judgment.
So we are not
Agree. That yesterday I submit, but this is the
I have a strong feeling, subject to my brother concurring with me, but that this can't be done. And if this is accepted, I think it will open a Pandora box for all and the sundries managing committee
Complete chaos.
to usurp the
Powers of the state and the statutory board.
of legislation.
But in fact, not
Very, very, very dangerous trend.
the consequence of 10C being upheld by this court.
No, no, 10C.
Yes.
I have also
10C is not applicable.
said that how gradually the power shifted from the managing committee and vested into the commission and the board.
But here state can transfer any person.
No, that is not the case here. The state has transferred any.
No, I was with
You
the
have
evolution of
invoked-
law, but has fell from the bench.
Now you have invoked the jurisdiction under the transfer rule and the special ground, whatever it may be, your lordship.
No, that is what he says is kindly visualize if this proposition of law is accepted.
But that is the charge.
Even in case of a transfer, it is the recommendation of the school service commission in case of transfer as well.
Well, suppose
And the transferor school or the transferee school, he may say, I will not permit him to join.
No, but that-
I have a,
that-
which is
Exactly,
done.
that's the-
Which is done.
exactly.
I will not permit you.
That power is also gone now by reason
Not
of the
permitted.
2018 amendment and the 2017
Now,
amendment. This is also gone now. They can't object even.
Well,
10C was introduced on 9th of April 2017 or 10th of April 2017. Now in 2018, the board is,
You are saying.
your lordships have laid down the law. And 2018,
Where is that judgment of 10C?
well, 10C is not applicable.
No, it's a
No, I tell you, lordship, they have utilized.
it is a
They-
repository of the
Well, that
development.
is- that is- 10C was not there, 10C was not invoked. It is not the case of the 10C.
Oh, it is not I'm talking about, sir, the evolution of the education system. in the state.
That is one of the academic discussion.
paragraph 50 onwards, not maybe.
The rule of the minister is heavily deprecated by the division bench. Application made without bypassing the schools. Not the case of the 10C. হ্যাঁ, ভালো কিন্তু। পুলিশ
Paragraph 66 note is exactly not what your lordship note was observing a few minutes back. The concept of appointment in school in perpetuity has been gradually eroded and has held in the above noted decision.
This was not cited
No, probably not. No, this was not.
before that.
It is not the case of the 10C because the recommendation was made.
This was 2016.
Yes,
But ultimately, the decision was taken in 2018. So that the law prevailing on the date of consideration would apply.
transfer order was issued on 11/1/2017. 10C was not there.
Board was implementing the transfer.
No.
Right. 2018, the board was implementing.
Now, my lord, my second leave of submission.
No, you consider you simply cited us for that reason we invited. He has not argued actually. So let him argue first.
No, other, so far as the locus is concerns. The interest
That you will take the plea when your turn will come. Let him first. It is only on college judgment you wanted to cite, I just kept.
Number the point of locus is answered by the Honorable Single Judge in paragraphs 24 to 31 of the judgment. Paragraph 24 is at page 14 of the judgment under appeal. Submissions on maintainability. Internal page 14.
Compilation.
Compilation running page 45. Internal page 14 of the judgment. Mr. Bari, learned counsel appearing for the managing committee of the school makes his composite submission for the writ petitioner in the writ petition being so and so. At the threshold on the commencement of hearing, this court has raised the issue as regards the locus standi of the managing committee of the school to maintain the writ petition to resist the transfer recommendation in favor of the teacher. Learned counsel, in reply to the issue raised by this court as stated above, submits that the entire administration and affairs of the school, which inter alia includes imparting of education at the society, is supervised and managed primarily by the managing committee of the school. If any irregularity or illegality takes place in running the administration or the affairs of the school in any manner, the primary responsibility vests upon the managing committee of the school. It is the responsibility of the managing committee of the school to look after and maintain the standard of education imparted by the school in the society at large, and failing which, the managing committee shall be primarily responsible for not discharging its obligations under the relevant guidelines.
These are the recommendation of the family council as well. Because
Yes.
the council advised the government
Yes.
to improve the standard of education. Yes.
Now, he goes on to refer to the, please come to paragraph 25, sub rule 8 to rules 5 and rule 7 of the management of sponsored institutions, secondary rules 1972, submits that the composition of managing committee of a school statutorily requires guardians representatives. But I fail to understand why the constitution of a governing managing committee of a school should have any bearing to this case.
That's got
Nothing to do with the locus of the managing committee to challenge a recommendation and transfer. Now, please come to paragraph 31 straightway.
To say that there was a lot of commotion, a lot of resistance from the different corners of the guardians. So guardians representative being one of the managing committee, his voice has a very, very primary role, or must have a primacy over anybody's opinion.
Now, we have
Believe so. That is what
that's probably his apprehension or not voice.
the Bari can clarify that. But
Now, the court, the Honorable Single Judge accepts his submission only on the ground that rules 5 and 7 relates to constitution of managing committee where a guardian's representative has a say. And in that context, the court upholds the
but in a democratic polity, what is there? If the majority,
the majority might not have known. The majority might not have known that such an objection is forthcoming. Now, this is why, not in paragraph 66, not as in that judgment, which upholds the validity of 10C, your lordships have been pleased to record that why this power is being gradually taken away and why this erosion of power. Instead of not an individual being the repository of power, the state executive machinery is taking away the power for the purpose of smooth administration when it pays. And it's really the fundamental duties of a state to impart education up to after 14 years of age, 21A being part of fundamental right. Be that as it may, not if this situation happens, not your lordships have been pleased to record the gradual evolution of law on the subject. Number 1, 1997, the power to appoint, the recommendation. 2017, 2015, the transfer rules. 2017, 10C, state government's power to transfer. Then 2018, appointing authority, implementing authority for transfer, and disciplinary authority is all rolled into the board's action. So, a managing committee of a school in 2018 could not have any say with regard to implementation of a transfer order because the law on the date of consideration would apply and not an earlier law. This is apart from the question that even the rules of 2015 had struck a difference between transfer on special grounds and general transfer. The transfer on special ground has not taken away the general power of transfer.
exercises such power, whether it is a general transfer on a special ground or a general transfer.
It's the state authority,
State authority
commission, state authority.
is that if it is the state authority, if the state has taken a conscious decision to transfer, can a third party question that why you have?
But I'm deeply.
That is
That's
not
that's the
permissible.
short question.
Question is whether the school authority has any power to deny that I will not permit him to join.
But in fact, the 2018 amendment of the 1997 Act that confers power on the board to implement such transfer. That being the position, not where does the managing committee of a school possess locus standi to challenge such an order? But the state might have been alive to such situations, which is troubling the field.
Can we issue a continuous mandamus?
Your lordships can.
But it all depends. Mandamus is very
Risky, very risky.
Incorporating in a legal path.
Yes, that's true.
Based upon an unconstitutional state of affairs.
Today,
This concept originated somewhere in Brazil and
not yes, very foreign to our concept because not
state of affairs involving a continuous mandamus.
because not here not we have restricted separate fields for the power, but not where also not that is also judgment laws, not where it requires an inroad to be made. Not why this not we are not going into the legislative intent, why it was done. But once done, an executive, it's really an executive action based on formation of opinion, which has received statutory sanction or legislative sanction through incorporation of 10C and amendment in 2018. Otherwise, not if somebody is appointing, why should there be somebody else who is controlling the service conditions of an employee? Nobody has questioned the legislative competence, or not even if questioned has failed. Now, this is really a reiteration of a fundamental duty of a state, which is, though not enforceable, but receiving its legislative sanction. It's overseeing the performance of school in imparting education. But why did the legislators thought it fit to incorporate the 2015 rules? Not if you have learnt not the hierarchy of legislation, then not act is primary over rules. When in 1997 the statute has undergone an amendment to incorporation of 10C, then it has to be reckoned as primary. In 2018, when the board is clothed with power to issue such implementing orders, it has to be reckoned as primary. But why today the 1969 management rules has really gone to the backstage? Even rule 33 has been deleted, not which conferred power for the purpose of not certain rules to be made or certain action to be taken. And not when in 2018 the board was taking a conscious decision after hearing the school, the commission, the state government to implement such transfer recommendation. How 10C was already in existence and 2018 amendment has already seen the light of the day. And in that light or in that anvil, the school managing committee ought to have been declared to be lacking locus standi to challenge a transfer recommendation.
Because I have held that the 10C has to be given a retrospective.
Yes. Not an action or a law is not made for the purpose of rendering it unworkable. Yeah, and your lordships try your lordships utmost to preserve a law, even to the extent of going to the position of reading it down to protect its vires. And not all that the honorable single judge says is the management rules of 1972 lays down provisions for constitution of a managing committee. Therefore, there is locus standi.
Now the question is whether it is obviously it's a subordinate legislation. If the Parent Act has seen the radical changes, and if there is an inconsistency between the provisions contained in the Parent Act, Parent Statute, and the subordinate legislation, then it is a Parent Act will
Your lordships will not even look into the rules
because these management rules was framed in exercise of power
under 63 Act.
from the West Bengal
1963 Act, West Bengal Board of Secondary Education Act.
and there has been an amendment in the West Bengal Board of Secondary Education.
Everything is now controlled under new law. Not please see, not in fact, not why, not apropos, not I am since not your lordships are going into this, are making this observation.
Because of one reason, because we have to take a dissenting view.
No, that was first of all not that was a case where the governing body was considering a case of recommendation for appointment under a different law, which was not having powers, conferring powers on the authorities to make transfer or something like that. Transfer, appointment, disciplinary control, all is not accessible by the managing committee or the governing body under in
Case of an appointment, it will create a very alarming situation.
But that judgment was dealing with a separate situation which was not considering this law. So it will, prima facie, this will not have any application. But there was disciplinary proceedings pending.
No, please kindly consider, I'm thinking for a large, in a
Yes,
larger
in the,
perspective.
your lordships are considering it.
In a larger perspective.
But
there are two ways of doing it. Either we decide this particular writ petition on merit and then keep this particular point open and refer to a larger writ. One way of looking into it. So it will minimize your agony that my matter would remain pending before this larger writ. Second is that we refer it to the larger writ and then decide.
not, please take, not, probably this may not be necessary in view of, not, please have a look at not the, this is a very interesting thing, not, it surfaced not while reading the rules.
Yes. Yes.
But your lordships not were considering the evolution of law on the subject. Not, please see, not, I have handed up a compilation today. The 1997 Act, then the 2015 rules, and the amendment to the 2015 rules. Yeah, then.
Yes. Page.
But that's page 18.
18. Yes. What?
No, this is an amendment to the 2015 rules.
That's the rules.
No, just please have a look. No, it makes a very interesting reading. Please come to page 19.
Yes.
But there is a second proviso to rule 6 sub rule 2 under E.
Where?
Clause E, page 19.
19 or 18?
It begins at 18, at 19. At 19. The one which I just now handed up.
That's 19. Rule 6. Oh. Rule 6, yet second provision.
For rule 6, substitute the following rule.
Not properly. No. There is, what you are referring, you are referring this,
No, I have
this March 11, 2015 notification, that rule.
No,
No,
8 September 21,
2021.
but the second compilation that I handed up today just.
Oh, second compulsion. Oh, that's anyhow, yes.
September 8, 2020.
Please come to page 19.
Yes,
It's an amendment of 2021 to the 2015 rules.
yes.
Please come to the second proviso to clause E of rule 6 as
Yes.
substituted.
Yes.
Provided further that the central school service
Majority বেশি হবে না minority হবে? দেখে এখন অন্য কিছু নিতে চাইছি। বলে দেবে নাকি? Look, it's another matter which is.
I know, Malad, the original said, Malad, won't happen because, Malad, I'm told, Malad, they
Take
want
7
time.
days time. Good luck.
Yes, all the appellate side party.
আগে appellate side করুন।
For all the reasons as aforesaid, the appellant is permitted to file a complaint before the commission raising only the issues which fall within the jurisdiction of the commission along with the server copy of this order. If the complaint in the manner as directed herebefore is filed, the commission shall dispose of the same after making necessary inquiries and upon giving opportunity of hearing to the appellant, the clinical establishments and any other person whose presence may be necessary for an effective adjudication of such issues or their authorized representatives and by passing a reasoned order. A reasoned order shall be communicated to the parties immediately thereafter. The entire exercise shall be completed within a period of 10 weeks from the receipt of such complaint. The impugned order stands modified only to the extent as indicated herein before. Appeal application stands disposed of.
Urgent.
I agree. Yes. What's the next?
Item number 2 and 3.
Yes.
Milord, by the order of 16th of December 2024, Milord, my lords were pleased to, Milord, formulate the points on which, Milord, we are to address your lordships.
We forgot what point we opposite. Order.
16th of December 2024.
We have the order, don't worry.
Yes. Milord, we have come up against rejection of our review application.
The only point is whether the review lies. I believe so.
No, a review has been taken up on its merit and has been dismissed.
Sorry.
Yes.
Appeal lies.
Appeal lies.
Yes.
Well, the first question which my lords have been pleased to frame is whether an order rejecting an application for review is a judgment within the meaning of clause 15 of the latest patent. And the second question is whether the rules framed by the High Court to regulate proceedings can override the latest patent.
Yes.
But these are the two, my lord,
Yes.
questions, my lord, or points which my lords have been pleased to, my lord, formulate. Well, I am a person, my lord, who have suffered before the learned single judge through rejection of my application for review. Suffered a rejection.
The act of sufferance.
Legal sufferance. Legal sufferance. Number I would, my lord, base my argument on point A, primarily on
Maintainability of the appeal against the order rejecting review application.
right. But the starting point is the application for review which has been filed Was it an exercise under Article 226 or an exercise under Order 47?
So you wanted to say that so far as the Article 226 proceedings are concerned, the power to review is ingrained in here in the court. It does not and cannot be controlled by the provision of Order 47. I think.
Yes, yes. But I can concede to this extent that if it is an exercise under Order 47,
Then no appeal.
then of course, my lord, Order 47, Rule 7 will stand in my view. Otherwise not. Therefore, my lord, my first endeavor would be to demonstrate before your lordships that it is an exercise under Article 226 itself. But before that, I think, my lord, a few provisions of the Civil Procedure Code and, my lord, the latest patent, my lord, I think, my lord, requires your lordship's consideration. First is, my lord, whether an order rejecting a review is a judgment within clause 15 or not. But on that, my lord, straight away, my lord, Khimji has considered this point and rendered a finding on this, that an application, that an order rejecting a review is a judgment within the meaning of clause 15 of the latest patent.
That's what remains.
Yes. Therefore, my lord, according to me, nothing remains.
His judgment and the matter ends.
Yes.
Then
But your lordship,
put so much of labor on that.
well, kindly have a 81 foot a day. Yeah, our judgment will go.
Give us the Babulal Khimji's judgment.
अच्छा अच्छा तो कैसे ये तो सर ये तो but as your lordships know that Khimji was primarily considering whether an interlocutory order
This is what I really.
yes is a judgment or not. But your lordships, ये ACC online take করেছিস প্যারাগ্রাফ যদি নাম এলো But I think your lordship kindly take this copy. But I think that's SCC online. Please take this copy. একই ও তাহলে ঠিক আছে তাহলে then it's all right, then it's all right.
81 volume 4 SCC.
Yes, yes. আমি বলে দিচ্ছি কি করবো বলতো চেয়ার টেবিল অ্যারেঞ্জ করতে আমি যাবো কি মুশকিল বলে লজিস্টিক পাচ্ছি না। But your lordships, my lord, amongst others, please have a look to me at paragraph 102 at page 51, bottom.
Yes.
Again, in Union of India versus Mohindra Supply, this court clearly held that in enacting section 104, the intention of the legislature was to preserve the latest patent jurisdiction of the High Court and to provide for a right of appeal from the trial judge to the division bench without affecting the Code of 1908. In this connection, the court observed as follows: under the code as amended, the view has consistently been taken that interlocutory judgments, that is, decisions though not amounting to decrees, which affect the merit of the questions between the parties by determining some right or liability, passed by single judges of chartered high courts, were appealable under latest patent. We might mention here that the observations of this court completely demolish the arguments of some of the high courts that section 104 does not apply to internal appeals in high court, because this court, while referring to the code, made specific reference to section 104 in the previous paragraph. Apart from this, there is no observation by this court regarding essential requisite of a judgment. In state of UP versus Dr. Vijay Anand Maharaj, the order impugned passed by the single judge was an order dismissing an application under a file by the application to review the order of the trial judge. The question for determination was whether the order was a judgment so as to be appealable to the division bench. This court referred to the observation of Hidayatullah J. extracted in Manohar versus Baliram, and though they did not expressly approve this decision, they indirectly seem to have been impressed by the reasons given by Hidayatullah J. Nothing further was said by this court because it held that on the facts of that case, the order of the trial judge dismissing the application for review was appealable. We might mention here that clause W of Order 43 Rule 1, an order granting an application for review is appealable. On a parity of reasoning, therefore, an order dismissing an application for review would also be appealable under latest patent, being a judgment, though it is not made appealable under Order 43 Rule 1. Therefore, my lord, I said that here, my lord, the Supreme Court was considering the nature.
Another object, but a point, but anyhow.
Yes.
Had an occasion to consider this.
This.
And really taken clue from Manohar versus Baliram.
Right.
And this Manohar versus Baliram is the judgment of the High Court or a Supreme Court? Nagpur, High Court.
This court means Supreme Court.
No, 52 Nagpur.
Manohar versus Baliram.
Now is the EIR 1950. Nagpur, case 357.
Milord, Manohar versus Baliram is Supreme Court.
No.
Vijay Anand Raj Maharaj is Supreme Court. Manohar versus Baliram is Nagpur.
Okay, Nagpur.
This is what the Dr. Vijay Kumar Anand's judgment.
Yes.
Yes.
That is the Supreme
Absolutely, brother.
Yes.
Absolutely.
Yes.
Yes.
Therefore, my lord, the Supreme Court, my lord, had the occasion to incidentally consider this issue, and my lord has rendered this finding that an order, an order rejecting a review is also a judgment, my lord, within the meaning of clause 15 of the latest patent. Number, if your lordships want me to, my lord, explain further, but I can proceed. But I think, my lord, this clinches the issue.
Is there any subsequent judgment extending the key or
My lord, there is a
directly on the point?
But I have got judgments, my lord, on the last one, which, if your lordships kindly recollect, I have that judgment once more. A special bench, my lord, of the Madras High Court of 2021.
Justice Banerjee.
Justice Banerjee.
Yes.
There also, my lord,
But the three judge bench of our High Court.
yes. Now, so far as, my lord, but in fact, my lord, on the last occasion, my lords were pleased to refer to a 7 judges bench of Justice Bhaskar Bhattacharjee, where Justice Bhattacharjee was pleased to, the bench of Justice Bhattacharjee was pleased not to accept, my lord, Ratanlal Nahata. But with respect, subject to correction, Justice Bhattacharya's special bench does not consider Khimji, at least this paragraph of Khimji. Now, going one by one, first, now, my lord, in this backdrop, my lord, if required, let me first get over the applicability of the provisions of CPC in respect of the subject matter with which, my lord, we are discussing. Should the provisions of CPC override the latest patent or vice versa?
I don't think so. I think the point is that latest patent remains untouched.
Right. Number one. Number two is, to do away with, my lord, the provisions of latest patent, there has to be a legislation to that effect. For example, section 100A of CPC.
No, let us see.
Hmm.
Legislation, when you say, take the example of the Commercial Courts Act.
Right.
Take an example of section 30, when the right of appeal is provided.
Right.
It really takes away the applicability of the latest patent there. Says that the latest patent will not.
Yes. But I was trying to give that example through section 100A. Please have a look at section 100A.
Look at that provision of this the commercial code. You will find.
But yes, but I don't have the commercial
Even
codes.
of the applicability of the latest patent is expressly it is given.
Yes. And this is also, this flows from, my lord, clause 44 of latest patent, that the legislature can truncate latest patent, not otherwise. Kindly, my lord, have a look where latest patent touch it. Please have a look to, my lord, 44 clause 44 of latest patent. Latest patent আছে?
What is this?
The latest patent evaluation.
Original side group say
Real side rules are creation.
every original side rules book contains that latest patent.
Really?
না মোটামুটি থাকে আপনার সেক্টর হ্যাঁ Unfortunately, this book does not. My brother's book contains.
ওইটা বোধহয় একই বই।
672. 672.
আচ্ছা, না জজসাহেবের কাছে আছে।
Yes. Yes, we have. We have. Don't
Yes. Please take, my lord, clause 44. We do
Laws of the Indian legislature preserve.
We do further ordain and declare that all the provisions of our latest patent are subject to the legislature powers of the Governor General in the Legislative Council and also the Governor General in the Council under Section 71 of the Government of India Act as also Governor General in cases of emergency and may be in all respect amended or altered thereby. Therefore, my lord, the powers of the legislature to amend, alter, do away with the application of latest patent is provided in the latest patent itself.
Yes.
Therefore, in order to take away the right against right of appeal against rejection of review, there has to be a specific provision in the Civil Procedure Code or any other law. Therefore, please compare 100A with Order 47, Rule 7. Kindly make this comparison.
Can we not look the matter from a different angle as well?
Yes.
If the, under the Code of Procedure, the right of appeal against an order rejecting the review application is not provided. The right of appeal against an order allowing the review application is provided. Then the question would be whether a person would be rendered remediless. Under that, Section 115 talks about that where there is no right of an appeal, then the challenge can be made under Section 115. So far as the chartered high courts are concerned, since they are guided by the provisions of the latest patent, there is no provision for a revision to be gone into against the order of a second. So a person cannot be rendered remediless for all time to come. And if the horizon of clause 15 is expanded, which engulf within itself any kind of an interlocutory order affecting the rights to be an appellable order, then why not this time against the rejection, the appellable, it should be appellable.
Yes, ma'am. This can be also looked into from that angle, definitely. Through that avenue.
Ubi just ibi remedium. This is what is the principle, which is the doctrine which is playing in my mind.
Where there is a right, there must be a remedy.
But there is an exception to it because it was a clause 13 application under the original side rules. It is not regarded as an order.
Yes.
The transfer. And then straight away you have to go to
Supreme Court. Because it's not a judicial order in the true sense of that.
It's a judicial order.
No, but it is not a judicial order in the true sense of the term. For example, I'll give from the criminal side, an order, my lord, passed under Section 321, dropping prosecution.
That clause 15 takes care of
Yes,
that.
yes.
If it takes size of the criminal jurisdiction, then the clause 15 does not have any manner of application. Otherwise, there will be a multiple appeal in this regard. Ram Kishan Fauji's case, I think, of the Supreme Court is very important.
Very, very important. Very important in the sense the Supreme Court, in my very humble submission, should have, my lord, explained what is meant by a writ court exercising criminal jurisdiction. That is very, it is very vague, if I may use this expression with respect. When does the writ court exercise criminal jurisdiction and when does the writ court exercise civil jurisdiction?
Fauji says, talks about that. Writ court exercising criminal jurisdiction.
Yes.
That is, the only catchword is the quashing of the proceeding
Or initiation.
or initiation of the proceeding. Our erstwhile the Chief Justice, Justice Radhakrishnan, has explained it.
Yes, yes.
It's just for rigid manner.
Right. But we are taking note of that judgment.
And then says that since it was not for quashing,
Yes.
no criminal jurisdiction.
But the other division bench, subsequent division bench, will have presided over by Justice Talukdar.
That cannot be done because the earlier judgment, if you want to take a dissenting view, then you have to refer the matter. You can't. Latter judgment will not be regarded as a good one.
But
There was no discussion by Justice Talukdar.
But the
straight away jumping to a conclusion.
but difficulty is Justice Radhakrishna's judgment did not go to Supreme Court. But Justice Talukdar's judgment went to Supreme Court, SSP dismissed.
Not a merger.
Yeah.
Oh, TBR.
Yes.
Therefore, my lord, if Khimji is accepted, if your lordships are with me that it applies, I don't think that I need to labor much. I've got 20 judgments. I don't know whether I should proceed further or not.
Including my brother was telling me Andhra Pradesh High Court judgment.
Yes, Andhra Pradesh.
Judgment.
Rather, Andhra Pradesh, I do not know what judge.
Sinha's judgment.
Yes, Justice Sinha's judgment is 2001.
Holding that it lies, but the dissent was there of the another judge.
Yes,
Brother
but the other honorable judge
does not lie.
but the other honorable judge's judgment, is not that elaborate as that I must concede. I must concede. Yes.
But also elaborate. 4 pages.
No. Justice Sinha's judgment was elaborate, but the other honorable judge
Took note of the division bench of that court, earlier
Yes.
division bench and other judgment was there.
but the other honorable judge held that the review
Happened any reference from that judgment because there was a dissenting view.
reference made I have not checked up. It was 2001 SCC online, Andhra Pradesh 1034. It was a full bench judgment.
There were 2 judges, division bench.
No, but I found, my lord,
That division bench considered the full bench.
I see. No,
All the judges
I've
considered that.
I have not, I could not lay my hands on that. But full bench I have with me,
Full bench was considered in a subsequent division bench. Both
1035. 2001 SCC online, Andhra Pradesh. এই নাম বলতে পারছি না, তাই বলে দিচ্ছি। না, মদন দাস versus no, not sorry. No, sorry.
According to you, this particular Khimji's this observation is untouched anywhere.
Rather, my lord,
The judgment taking a contrary view did not take note of the Khimji's judgment. According to you,
Talking about the
have you checked up?
no reference.
Have you checked up?
but till 2021, this is holding the field. I have not been able to find out any contra judgment which refers to that paragraph 103 of Khimji and then says something else. But that has to be Supreme Court, not any High Court. Very well. Then will I take my
Let us hear him. If we can bring any changes, then we will invite you to us.
well.
Yes,
First, my lord.
Judgment,
Yes.
observation. I think that point can't be decided by us. Paragraph 123, the
103.
last sentence.
103. Madam, may I read 103? Yes, madam. May I read 103 with your lordship once? I will cite one authority. We might mention here that the observations of this court completely demolish the arguments of some of the high courts that section 104 does not apply to internal appeals in the high court because this court, while referring to the code, made specific reference to section 104 in the previous paragraph. Apart from this, there is no observation by this court regarding essential requisites of a judgment. Next sentence is most important, my lord. My lord, the basis of this paragraph is the judgment rendered by the Supreme Court in state of UP versus Dr. Vijayanand Maharaj, which in turn follows the observations made by Justice Hidayatullah in the Nagpur judgment. So having regard to this, I would like to place AIR 63 Supreme Court. Now,
No, read the last sentence.
yes. I'm conscious of that. The last sentence says that yes, the order dismissing a review on the same analogy as on the basis of Dr. Vijay Anand Maharaj.
The interpretation one can have. Now, can we go? Let us go to
Right.
another.
Right.
Suppose a judgment is considered by a bench of the Supreme Court.
Right.
And in the judgment, they clarify what is perceived from that judgment passed by the Supreme Court at an earlier occasion.
Right.
Now, can you cite that earlier judgment and say that it cannot be a
No, my lord, I am not on that. What I am submitting before your lordship, in Dr. Vijayanand Maharaj, the review application was a statutory review application under a specified act. It was not a review under Order 47. And that is why that or judgment was held to be appealable under Order 43, Rule 1. And Clause 15 of latest patent.
No.
I will place that judgment.
Under the special act,
yes,
then the Order 43 does not lie.
Clause 15 would lie. Clause 15 would lie. What happened in that case?
Clause 15 will lie.
Malad, may I just explain to your lordship? Malad, in that case, what happened? Is an act was considered by the High Court. By the High Court. Malad, that certain provisions were held to be invalid by the High Court. The state legislature brought about an amendment, a validation kind of act. By introducing the Validation Act, a provision was made in the Amendment Act that you can prefer review application before the High Court in the light of those amendments. My lord, on the strength of the statutory provision, applications were made before the High Court concerned. The High Court dismissed those review applications. That order was challenged before the Supreme Court. When the Supreme Court considered that matter, Supreme Court specifically held that yes, appeal under Clause 15 latest patent is maintainable, but this is not a case where, my lord, the court had exercised power under Order 47, Rule 1. That's the sum and substance of Vijay Anand Maharaj. And on that basis, this judgment was delivered. So, my lord, when the Supreme Court speaks about review in paragraph 103, it is not a review under Order 47. It is a statutory review arising out under some act, a state act. And I will place that judgment. There is a specific observation made by the Supreme Court in Vijay Anand Maharaj that this cannot be considered to be a review application under Order 47. That is why, my lord, these observations do not find, my lord, place in the final conclusion arrived at by the Honorable Supreme Court in Shah Babulal Khimji. It speaks about preliminary judgment, intermediate judgment, final judgment, what is a judgment within the meaning of Clause 15 latest patent. But this is one such case where the review was a statutory review. But I knew that this paragraph would be placed, so I got myself ready by reading that 63 Supreme Court. यही है ना? ठीक है, no problem. May I just hand up our compilation to your lordship? পেজটা হচ্ছে তোমার এটা আমার কাছে এসসিসি অনলাইন আছে, এই 62 এসসিসি অনলাইন এসসি 12 12 हाँ हाँ না এটা অন্য তখন তখন তো স্যার স্যার বোধহয় স্যার এনরোল্ড হয়েছিলেন হ্যাঁ 61 এনরোল্ড বলা যায় না বাপু সাহেব হতে পারে হি ওয়াজ জুনিয়র টু এইচ.এন. সান্যাল হেম সান্যাল না নামটা দেখবেন বাট ওকে কে পিইউ হ্যাঁ স্কিল কাপুর পিইউ আর লিখতো হেম সান্যালের জুনিয়র ছিলেন না এইচ.এন. সান্যাল হচ্ছে হেম সান্যাল হ্যাঁ কোয়াইট পসিবল এখান থেকে নিয়ে গেছে জুনিয়র এটা এসকে কাপুর ছিল কিশোরদা 62 তে হেম সান্যালের জুনিয়র ওনার বোধ হয় 59 এর এনরোল এই প্যারাগ্রাফটা হেম সান্যালের ছিল না তাহলে বলতে পারছি না তাহলে অন্য কাপুরও হতে পারে করতেই পারে এই যে order 47 GB at all no it's a passing observation based on this judgment so not applicable in the facts of this case and was review at all maintainable having regard to section 114 that they had already preferred appeal against that order 114 the code first clause to that take 114 hit by clause A. Hit by clause A.
Yes.
Well, may I place, my lord, this Vijay Anand Maharaj, can you kindly take our compilation? একটা আরেকটা copy দাও some of the paragraphs only, my lord, not the entirety of the judgment, but it is crucial, my lord, because your lordships would be laying down the law in this case. হ্যাঁ দিয়ে দে কিশোর দাকে
আমি ডাউনলোড করে দিচ্ছি
my lord, kindly take paragraph 2 of this judgment. Kindly, my lord. Paragraph 2 of the 63 Supreme Court. The facts leading up to the filing of this appeal may be briefly stated. The respondent held certain zamindari and agricultural properties in different districts of the state of UP on December so and so. Additional Collector Banaras, in exercise of the powers conferred on him under the provisions of the UP Agricultural Income Tax Act, assessed the respondent to an agricultural income tax of rupees so and so for the year so and so. On September 30, 1955, the respondent filed a petition before the High Court under Article 226 of the Constitution for quashing the said order on the ground that the additional collector Banaras had no jurisdiction to make the said assessment. On November so and so, Justice Mehrotra allowed the writ petition quashing the said assessment. I'm sorry, madam. State of UP did not prefer an appeal against the said order and allowed it to become final. On February 9, 1956, the state of UP promulgated an ordinance being so and so, which was subsequently replaced by the Act of 56. Under the provisions of the ordinance, the assessments made by additional collector were retrospectively validated, and under section 6 thereof, a right was conferred upon any party to the proceedings under the UP Agriculture Income Tax Act, wherein an assessment made by an additional collector or additional assistant collector was set aside merely on the ground that the assessing officer had no jurisdiction to make assessment, to apply within 90 days from the date of commencement of the said ordinance for a review of the said proceedings in the light of the provisions of the ordinance. and a statutory injunction was imposed upon a court to review the said order accordingly. Pursuant to the provisions of Section 6 of the said ordinance of so and so, the appellants filed an application in the High Court at Allahabad for review of its order dated November 22, 1956. Subsequently, as stated earlier, the ordinance was replaced by UP Act of so and so, hereinafter called the Act. In course of the judgment, we shall refer only to the provisions of the Act. The said application was heard in the first instance by Justice Mehrotra, and he held that Section 11 of the Act, which corresponds to Section 6 of the ordinance, did not entitle the petitioner appellants to file an application for review of an order made by the High Court under Article 226 of the Constitution. The appellants preferred an appeal against the said order to a division bench of that court. Chief Justice Mutham and Justice Srivastava, who heard the appeal, dismissed it on two grounds, namely under so and so chapter, a special appeal against an order of single judge of the court can be maintained only if that order amounts to a judgment, and an order refusing an application for review not being a judgment cannot be subject of an order of an appeal. Two, on merits. That is, on the construction of Section 11 of the Act, the view taken by Justice Mehrotra was correct. So, on that basis, now, my lord, kindly directly come to, my lord, paragraph, this is paragraph 4. Where, my lord, they consider clause 10 of the latest patent of High Court of Allahabad. They refer to, my lord, Orient Peace for Calcutta, Justices of the Peace for Calcutta versus Oriental Gas, the judgment. Then, my lord, they refer to the wider view. It continues. Then comes, my lord, kindly turn over and take paragraph. It is continuation of, in fact, paragraph 4. Kindly take, my lord, the sub-paragraph beginning with the words, the Lahore High Court. My lord has got that? The Lahore High Court generally followed the view expressed by Madras High Court. The Allahabad High Court in Mohammad Naim so and so expressed the view that an order which is not appealable under Order 43, Rule 1 of CPC, is not appealable under Clause 10 of the latest patent. This view has been followed by a division bench of the same High Court in Trimal so and so, but the said decisions do not attempt to lay down a definition of the expression judgment in the latest patent. The Nagpur High Court in Manohar versus Baliram, 52 Nagpur, this is AI also reported in AIR, full bench, by a majority after considering the case law on the subject, laid down the following definition. Justice Hidayatullah, who delivered the leading judgment, laid down the test at 522. But this is the test which has been applied at paragraph 103. A judgment means a decision in an action which, whether final, preliminary, or interlocutory, which decides either wholly or partially but conclusively. In so far as the court is concerned, the controversy which is the subject matter of the action, it does not include a decision which is on a matter of procedure, nor one which is ancillary to the action, even though it may either imperil the ultimate decision or tend to make it effective. The decision need not be immediately executable per se, but if left untouched must result inevitably without anything further save the determination of consequential details in a decree or decretal order, that is to say an executive document directing something to be done or not to be done in relation to the facts of the controversy. The decision may itself order that the thing to be done or not to be done, or it may leave that over till after the ascertainment of some details, but it must not be interlocutory, having for its purpose the ascertainment of some matters or details prior to the determination of the whole or any part of the controversy. The foregoing brief analysis of the judgment shows that the definition given by Madras High Court is wider than that given by Calcutta and Nagpur High Courts. It is not necessary in this case to attempt to reconcile the said decision or to give a definition of our own, for on the facts of the present case, the order of Justice Mehrotra would be a judgment within the meaning of narrower definition of that expression, that is the Nagpur view, my lord. Now, my lord, kindly take, my lord, now paragraph 5. My lord has got paragraph 5. Your lordship will find section 11 being quoted at paragraph 5. This is the provision under which the review applications were filed. And now, my lord, kindly come directly
realize
Yes. Yes.
the fact that the agricultural, the income tax act on agriculture
Yes.
was officially imposed.
Yes.
There was a demand by a SSA.
Yes, officer. Yes.
This was challenged before the High Court.
Right, my lord.
26 not under any statute.
Yes, under 226. Yes.
Mr. Malhotra, who was taking up those matters, declared that you can't.
You can't. Absolutely, my lord. This
The officer is not competent
right.
to raise this
Right.
demand,
Right.
and it was cost.
Absolutely, my lord.
The government then was of the view that we will be losing everything.
Yes.
There was a legislation which was brought.
Right, my lord.
By virtue of the legislation,
Right.
though that particular thing was passed,
Yes.
they wanted to give something from a retrospective effect, some right,
Right.
and in order to negate effect of the judgment of Justice Mehrotra,
Right.
hence permitting the person that you can apply for a review.
Right.
The question that arose was this right of review
Yes.
emanating under the statute confers any right into a government
Yes.
to file a review before the court
Right.
extending to 26 jurisdiction.
Right, my lord.
It was held that this right of review is within the force of the law
Right.
of that amendment or the law.
Amendment Act.
So it must be at best the review of the order of the assessing officer, not a review by a decision
Right.
taken by the court
Right.
under Article 226.
Absolutely, my lord.
In this perspective, it was held, but not otherwise. So, question would be that what report really held in this judgment?
Yes.
If the review under Article 226 is maintainable,
Right.
then in that event is a bigger question. You are trying to make a distinction.
Well, paragraph 12 gives the answer.
No,
Kindly take paragraph 12.
I have not read it.
Kindly take paragraph 12. Your lordship will get the answer at paragraph 12. They consider Article 226. And lastly, what was argued? Lastly, it is contended that even if Section 11 does not apply, we should treat this application filed by the appellants under Order 47 of the CPC.
Yes.
Yes.
I did not consider this 11.
Yes, ma'am.
Very interesting provision.
Very interesting.
It goes against the Tata Salute. Now,
This is what has happened.
legislatures we made to nullify the judgment.
Malad, it can. Malad, the basis of the judgment can be removed. As your lordship has seen from my lord, this first is that is
talking about Tata Salute.
yes.
Yes, you can't nullify that.
Yes. But the recent judgments are, my lord, state of Tamil Nadu.
It has frustrated you.
Lordship may recollect, my lord, the Malla Periyar case, state of Tamil Nadu versus state of Kerala, where identical views were taken. That to what extent, my lord, the judgment can be nullified. Then we have to go back to LIC case. We have to go back to Kaveri case if we take that perspective of the matter. Then, my lord,
Sahabanu also.
Well, I don't want to go that back. So, well, this is an arguable case which I am trying to make out with your lordship. And your lordship, while considering paragraph 103, your lordship would, well, in my most respectful submission, my lord, would kindly consider this judgment, and in the light of this judgment only that observation was made. When it was not a case of Order 47 review, specifically held, it was a case of a statutory review. Well, the lordships have taught us, well, the judgment is an authority for what it decides, not for not for that, what can be logically deduced therefrom. Because we have to also consider, in any litigation, there must be a terminal. There must be a terminus. If there is no terminus in a litigation, my lord, the entire proceedings, my lord, would result in multiplicity and recurring multiplicity. There would be no end to a litigation then.
The principle, these are based on public policies.
Yes.
That's why the limitation acts were enacted. The policy of section 11 of the Code of Civil Procedure.
Absolutely, my lord, that is why that exactly.
Finality has to
Yes,
be,
finality.
because it should not
Yes.
be in blood or
But in my compilation, I have given 3 illustrations where the Supreme Court has applied these finality clauses in different provisions of CPC in writ proceedings. Section 11, Sarguja transport,
rule 2.
or to rule 2. Well, I have brought those line of judgments for your lordship's kind consideration.
Brings acquittals.
Yes, 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 yes. My lord, Mr. S. Bhattacharya knows that I was about to give up this point. Then I thought, my lord, I have to assist your lordship.
Vijay Kumar, this
Yes.
judgment,
Yes.
do not know whether the judges consciously avoided to answer it. If you come to page.
Yes, my lord, I am at Vijay Kumar. Kindly, my lord.
Paragraphs 11 and 12.
12.
Finally did not answer.
12 come.
Yes.
12.
Come.
In fact, the last sentence in para 11 also.
The classical.
Yes.
But if you come in the middle of the paragraph 12, the sentence beginning, this is therefore.
My lord, I am reading from
therefore,
AIR.
This is therefore a highly belated event.
Highly belated.
Now,
Yes, yes.
to convert the application filed in one on one basis.
Yes, I have got it. I have got it.
That of another.
Yes, 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 my lord.
But the plea that if allowed, is not innocuous or a smooth sailing. But is brimming with many controversial issues.
Yes.
Then it raises the following question. Very interesting.
Very interesting, my lord.
Whether the application as one made under order 47 of the court was within time, we are not concerned. If it is out of time, could the delay be excused without the appellant filing an application for excusing it and giving valid reasons for the same? 3. Whether an appeal, an order made by the High Court in the size of its power under Article 226, could be reviewed under Order 47 of the court, and if not,
under Section 151.
4. Whether the amendment of the Act with retrospective effect could be treated as an error on the face of the record,
Right.
or as a sufficient cause within the meaning of 47 for reviewing the final judgment and decree made by the court on the basis of the law obtaining at the time of same orders were made. Then 5 is very important.
Most important.
If the order of Malhotra J was made under Order 47 of the court, would an appeal lie to a division bench of the High Court under Order 43? We do not propose to express any opinion.
So, my lord, the issue is res integra. Issue is not no longer res integra. My lord, she will decide this issue. My lord, kindly hear.
The Khimji is.
My lord, Khimji is based that paragraph.
Whatever is considered, if it has interpreted this
My
judgment
lord,
in a
this
particular
interpretation, Khimji does not say.
Can we go beyond?
My lord, lordship will certainly go into that because my lord, Khimji is based on this judgment.
True, but can we take a different?
My lord, your lordship it's not a question of taking different view, my lord. No, my lord, this is a question of interpreting the judgment.
The last sentence.
Kindly take Khimji once.
Last sentence. On a parity of reasoning.
Yes.
Therefore, an order dismissing an application for review would also be applicable under the latest patent being a judgment. Though not a judgment applicable under order 43.
My lord, the lordship will also consider.
Now, please consider that some of the questions which was left is now answered in Khimji by.
My lord, I tell you, lordship, my lord, the answer would be, my lord, reconsider.
Whether the inspiration derived from this judgment of.
Well, it has been referred to in the judgment. No, I do not want to get into that. My lord, the answer would be subject to lordship's kind consideration, obviously, my lord. Whatever your lordship will finally hold, your lordship will hold. Subject to your lordship's kind consideration, your lordship is dealing with an intra-court mandamus appeal. My lord, Khimji, subject to correction, perhaps was not an intra-court mandamus appeal, right? So, my lord, whatever, my lord, this, so far as this judgment is concerned, this was a case of intra-court mandamus appeal. This was a case of intra-court mandamus appeal.
Case of intra-court appeal.
Mandamus appeal. Well, let me check up.
Not.
I do not know. Well, I have to check up. Well, I may be incorrect. I may be totally incorrect.
I do not know.
Well, I may be incorrect. I may be totally incorrect. I may be totally incorrect. Khimji the bar korto?
Order refusing the.
No, it's a suit.
Of a receiver.
It's a suit. Well, not 226. Receiver.
That's why I'm saying.
So, my lord, today your lordship will kindly have regard, subject to your lordship's kind consideration, all the judgments rendered regarding, my lord, dismissal of review application, dismissal of appeal, dismissal order dismissing review applications in 226 carried to division bench by way of intra-court mandamus appeal or LPS as the case may be, and, my lord, decide this issue, because your lordship would have to take into account the impact of Article 226. There are several judgments. My lord, the Madras High Court, which my learned Advocate General was referring to, Madras High Court proceeds on a basis, your lordship, I will cite that paragraph if necessary. In fact, one of the division bench, honorable division bench of this honorable court, a judgment which was given to us by my lord Mr. Justice Bhattacharya, not the old one, the new one, Robin Paul or something like that, my lord. My lord, Khimji was considered. And still it was held that no order dismissing review application is not appealable. 96. Shah Babulal Khimji was placed and considered.
Better before the 5-judge bench.
Where this matter? My lord, your lordship, my lord, this observation made by your lordship would tempt me that I concede. That I concede, my lord. But my lord, I thought, my lord, as an officer of the court, it is my duty to point out. It is my duty to point out because this will be guiding, this will.
Because we have seen this paragraph.
Your lordship has seen this paragraph.
The division bench, which you are referring.
Yes. Has not specifically applied its mind to this paragraph. My lord.
If he has not considered it, then we can definitely do it.
Yes.
If he has considered and interpreted in a different way, then that might.
Specifically, it has. My lord, may I just make it very clear to your lordship? No, my lord, may I make it very clear to your lordship? That paragraph of 103, that paragraph 103 has not been specifically discussed. My lord, I have to be clear. Whatever is there on record, I will place that. And look at this judgment. This judgment, my lord, kindly take the facts of this case just for the purpose of this purpose. An order is passed by the honorable single judge. The party, the state approaches the division bench. 2 appeals preferred, one by WBIDC, another by state. Division bench dismisses the appeal. No leave granted for preferring review. Is it not hit by 114 clause A? I put the question to myself. Is it a matter where, my lord, this kind of liberty should be given to this kind of appellant? Clearly hit by 114A.
If the appeal is maintainable, I have got the first right of audience. Let him not say anything on the merits.
Not merit, my lord, on the well, basic facts, foundational facts for determination of this issue, not on the merits, foundational facts for determination of the issue in hand, which your lordship is now considering. But this is not adjudicatory fact. Mr. Chakravarti is prompting me, so I am giving an answer to.
Why do you get distracted?
No, this issue has to be considered. Otherwise, my lord, it's a Kimji says this, it's over.
Not saying anything on this, but simply igniting a spark to.
So, my lord, the exact expression comes from your lordship. It does not say anything. It does not decide.
But you ignite the spark so that it may turn into a devastating fire.
Paragraph 103 is not a judgment, it is the meaning of 16.
That's why
my lord, everywhere, my lord, unless and until, my lord, there is a wildfire, my lord, we don't know what would be the effect of wildfire.
that's why the first step is to, there must be a spark.
My lord, this is a issue which should not be doused. This is an issue which requires consideration. Well, my junior saying 5 জনের কাছে গেলে আমি সারেন্ডার করে দেবো, তার দরকার নেই। Because I have a good case on merit, that I know. But my lord, as an officer of the court, it was my duty to point it out. I have pointed it out. কালকে 12টায় সকাল বেলা 2টোর সময় করতে পারতো কিছু, কালকে ঝামেলা মিটে যেত। এগুলো বলো, একটা অ্যাডভোকেট জেনারেলের তো দায়িত্ব আছে।
যায় না এখন।
যাও না না,
আমি কি করে
in the judgment of the division bench.
মানে that is 96 though, ওই কম্পাইলেশন আছে এটা?
You have given a compilation.
Yes, my lord. এটা দেওয়া হয়েছে?
হ্যাঁ ওইটাতে আছে।
Yes, my lord, page 102.
102.
Robin Paul.
That's the last one.
Last one. I am sorry, man. That's the last one.
সাইটেশনটা বলবি?
হ্যাঁ বলছি না। 1996 1 CHN.
So if all judgment fails, then at least this is the judgment which
Right,
will
right.
come to your rescue. That's
Yes,
why the
yes.
last one.
No, my lord, our first submission before lordship is that paragraph of Khimji does not lay down the law. So far as my lord, order 47 rule 7 is concerned.
96 1 CHN page
411. তোমার রবিন পল ROBIN PAUL ভার্সেস কুমকুম মিত্তল। Khimji যেন কোথায় কনসিডার হয়েছে দেখো। Para 7, 8, 81, 5, 11, para 84, then many paragraphs, my lord. Para 91, sorry, para what 91? Para 14. Answer to কোথায় দিল? 20? না, এই প্যারাগ্রাফটা এক্স্যাক্টলি প্লেস হয়েছে কিনা আমরা বলতে পারবো না, এটা বলা উচিত হবে। 21 কোথায় আছে আমাদেরটা, আমাদের পয়েন্টটা কোথায় আছে? হ্যাঁ, whatever. এটা তো we have to think 29 my lord. Express bar. তোমার কম্পাইলেশনটা দিয়েছে তো কিছু। হ্যাঁ, হ্যাঁ, correct. Para 32, 33. না, বলা যাচ্ছে না, ওটা বলা যায় না। But the judgment was placed. And several paragraphs were placed. We don't know what was considered. বলারই না, ওটা বলাটা উচিত হবে না। Justice Nupur Gopal Mukherjee judgment. কে দাঁড়িয়েছিল এটা? আচ্ছা, এখানেই কিন্তু এটা কনসিডার হয়েছে, এই যে দি আর্লিয়ার ওয়ান, মানে দি 1878 না 60 জাজমেন্ট, মানে the earlier judgment of this our High Court, Musammat has also been considered here. Para 30. কি যাবে আমাদের যা মিস করে একটা এই জন্য বলতে পারে যে আগের যেটা আছে 3 জাজেস বেঞ্চ আছে, মানে 1870 এটা my reading is that. So it's a safety judge. আমার টানা এই তোমার ওখানে কি হলো 230 এই কিশোর বাবু হেভি খেতে বলছে আমাদের বলছে এটি কোথায় এটি কোথায় আমি ওই ফেভিকটা করে দে গোলমাল হয়ে যাবে রিডিংস কমপ্লিট হবে বুঝছিস তো আগে কি লিভ আছে আর আজ তারিখ মানে 28 ফেব্রুয়ারি ফ্রাইডে ফ্রাইডে রেখেছে তো আমার হ্যাঁ আগে 13 ফ্রাইডে রেখে 5 তারিখে কি ছিল Should the best boy in the class. Yes, no. Most dull boy. So this is what has been held by the division bench, and there is an earlier division 3 judges bench judgment in 1878, which your lordship may have seen. Malak, it is there in the compilation. But Malak, I would, Malak, if your lordship permits me, subject to your lordship's kind consideration, Malak, I would want to take your lordship to all the judgments which have been rendered in writ jurisdiction, so far as dismissal of review application is concerned. Subject to whatever your lordship would ask me to do, Malak, I will do that.
Yes.
Now, may I cite, Malak, these authority?
You have already cited 6 decisions.
Malak, the other decisions regarding, my lord, the proceedings arising out of writ petition.
Review.
Review. Dismissal of review.
You have not included in the compilation.
There is another compilation.
No, that is given. How many?
Oh, that is given. That is last day it was given. I can give your lordship directly the proposition and the relevant paragraphs. Full matter.
Second matter.
It's all another appeal.
Judgment আগে দিয়ে দিয়েছিস
Compilation copy आपको थोड़ा दिखाना এইটা না মানে may I give the propositions and the relevant judgments?
Yes. In another matter, there are many.
মানে paras মানে we have
That the judgment of justice, the judgment of Madras High Court.
But that was handed up by learned advocate. না Madras High Court judgment দিয়েছিল না তুমি?
Justice Banerjee judgment.
Yes.
মানে kindly
First
take
judgment is Ram Sahu.
মানে Ram Sahu মানে first judgment would be in the point of time would be, my lord, this Ram Sahu I will come to later. Ram Sahu is I am citing this judgment to distinguish Madras High Court, because Madras High Court proceeds on a somewhat erroneous basis that I will point out. Malad, kindly take, my lord, Shankar Motiram Nale. This is 94 to SCC short judgment, where, my lord, it has been held that an order rejecting a review application would not be appealable.
1 page order.
1 page order.
Paragraph order.
Right. Then, my lord, the second one would be, but this is one of such. Second one would be Sushil Finance versus M. Lata, 2004-13 SCC 675. Paragraph.
It is in relation to 226.
Well, these are arising out of 226 petitions only.
Oh.
I am taking a lordship directly to that. Just give me, my lord, one.
7 does not speak of that.
My lord, kindly give me 1 second, my lord. Kindly give me 1 second, my lord. No, Sushil is out of, my lord, NCDRC.
No, Shankar Motira.
Shankar Motiram Nale is out of, my lord. This is, my lord, not a suit. It is a suit. Next, my lord. Next, my lord, would be, this will be MN Haidar, which is the 226 matter.
Which one?
MN Haidar versus Kendriya Vidyalaya.
Yes.
These are 226 matter. Paragraph 4. Following the law laid down in Shankar Motiram Nale and Shivlal Singh Rajput and Sushil Finance. Malad has got that?
Yes.
Next would be, my lord, again a writ petition.
What it says, it simply says we are unable to accede to this request in none of these cases had it been considered. That was in the main order, special petition.
No, my lord, this is our orders dismissing review. Orders dismissing review, my lord.
No, what they were doing is that the special petition which was filed as sitting in order A was dismissed.
Yes.
They filed another special petition challenging the same order A.
No,
That
my lord.
perspective it was said.
My lord, kindly take the paragraph 1. My lord, lordship has MN Haidar, right?
Paragraph 4 is relative.
Paragraph 1, my lord, 1. These specialty petitions are against an order dated 18/12/2003, passed on a review petition, and an order dated 13/1/2000, 13/1/5/2002, 31/5/2002. Against the order dated 31/5/2002, a specialty petition had already been filed that stood dismissed. After the dismissal, after the specialty petition was dismissed, an application for review of the order was filed.
So once the review is dismissed, the special petition was filed assigning both the orders.
Yes, my lord, and the review, the SLP was dismissed.
Deprecated by the Supreme Court. That
Yes.
once it is dismissed, how can you file?
Both the orders are gone. But my lord, the review, the order dismissing the review was also carried to Supreme Court in that SLP. Then, my lord, the next one.
What can be logically deduced therefrom?
What can be logical? My lord, then, my lord, kindly take 2007-15 SCC 370. These again a writ petition.
Shivcharan.
Shivcharan. This is a clear, this is a writ petition. Challenge in this appeal is to the order passed by a division bench of Punjab Haryana dismissing the application for review filed in respect of so and so was dismissed. The said writ petition was dismissed on the ground that the writ petition was absent so and so. Learned counsel for the appellant, paragraph 3 I am reading, submitted that the High Court is not right in holding the review petition was not entertainable in view of material so and so. This clearly shows the High Court did not take correct factual position dismissing the review petition. Then they follow 6 and 7, Shankar Motiram Nale and this Sushil Finance and MN Haidar, and dismisses this SLP.
Next.
Next, my lord, kindly take. Yes. Straight away, my lord. Kindly take, my lord, well, I'm skipping that. State of Assam versus Ripa Sharma. This is page 51. The other judgment I'm skipping. I'm not relying. Read appeal. Para 2. এটা হচ্ছে page 51. State of Assam versus Ripa Sharma. But in this case, the challenging is the main judgment has failed in the facts of this case. Paragraph 5.
The different concept context.
Then, my lord, the next judgment is, my lord, the proposition is like this: no SLP against an order rejecting review application is maintainable when SLP against the main judgment was withdrawn without leave to prefer second SLP after exhausting the remedy of review before the High Court.
Yes.
But this is more or less akin to the, in my case, but this is a dusty book. This is your lordship's notebook or something like that. This is AIR.
Prior to the radical change and amendment having brought in 1970.
26. 76.
You've seen there are radical changes that has been brought.
Well, Mr. Learned Advocate General was referring to 100A underwent 2 amendments. 100 capital A underwent 2 amendments, in fact. Now, my lord, now kindly take paragraph, this is, my lord, page 54, paragraph 5 to 9. Well, here the SLP for, yes, my lord, page 54 of the compilation, paragraph 5 to 9. My lord, in this case, my lord, the proposition is like this, that no SLP against an order rejecting review is maintainable when SLP against the main judgment was withdrawn without leave to prefer second SLP after exhausting the remedy of review before the High Court. In my case, the first appeal, the appeal against the main judgment was dismissed. My lord, no leave was obtained at all. That I will come back after exhausting my review remedy. And, my lord, now they come up before your lordship by way of an appeal against the order dismissing review. And this is writ petition, my lord. Now, my lord, the next one would be, well, this is more exhaustive judgment. This is, my lord. Sandhya is also very exhaustive. Bassa Overseas 2016 4 SCC 696, page 60 of the compilation. Well, I thought my turn would come, my lord, 2 or 3 days later. I never expected that my turn would come today.
It has come after 2 3
Kindly take page 60. So, my lord, if your lordship kindly takes page 60, kindly take, my lord, para 15 to 19, where the Honorable Supreme Court discusses
all the judgments.
Yeah, referred, and, my lord, the interplay or regarding, my lord, Article 136 and Order 47, Rule 7.
Yes.
Paragraph 15 to 19. Then, my lord, on the last occasion, আমার আর কত মিনিট 20-25, হ্যাঁ লাগবে একটু মিনিট 20-25। আর তুমি কোথায় যাবে এখন? চলে যাও, ছেলেকে আজকে ছেড়ে দেবো। ওঠো না, ওঠো, তাহলে ওঠো। একটু ওঠো, উঠে বলো। এখানেই ও সেই কন্টেম্প টন্টেম্প আছে না, যেতে পারবে নাকি? না বলে দাও যে আমি যেতে আছে, কোথায় যাবে?
Yes, yes.
My lord, may I just proceed? My lord, kindly take, your lordship has taken paragraph 15 to 19, my lord, of Bassa Overseas. My lord, I will come back to Bassa Overseas for another proposition of law later on. My lord, then, my lord, learned Advocate General, my lord, in fact, during the course of hearing, Ratanlal Nahata was referred to. I mean, Ratanlal Nahata, subject to your lordship's kind consideration, perhaps stands little watered down in view of the law laid down in Madan Das.
Yes.
Now, Madan Das is reported in, my lord, AIR 2011, Calcutta 168. দেওয়া আছে compilation? Second টা আছে। মানে the compilation which we handed up today, this has Madan Das, man. Page 1, in fact. The first judgment in the compilation is Madan Das.
My lord, may I pray for an extreme indulgence, my lord? Extreme. Well, it is very unfair to, my lord, tell the division bench that I've got a matter fixed when, my lord, the matter is going on, but, my lord, it was fixed at 3:30. Could your lordship give me, my lord, excuse me for the rest of the day, my lord? Mr. Muzumdar would take some time, I believe.
তুমি থাকবে না সে সময়?
Yes.
Well, let him conclude today, my lord, whichever day your lordships would be sitting next, my lord. Kindly, my lord, permit me to reply.
So, my lord, I proceed, or my lord, what do I do, my lord?
Yes.
I proceed.
Yes.
Okay, very well. দেখো ডেটটা দেখে বল।
But your lordships must have hand sanitizers.
So I just wanted to ascertain because I find that order 47 rule 7 of the code of procedure is this first sub rule 1, subclause 1 has been totally amended by virtue of 1976, bringing the concept that the appeal against the order rejecting an application for review is not available.
Right.
So this was there. So I just wanted to know what was the prior. None of the books had at the bottom the existing provision prior to 1976.
No, it was all
amended
provision. Judgments of 1962, 63. At that point of time, 76 amendments were not there.
Yes.
So if those observations have to be considered, it has to be considered in that perspective.
Right. So, my lord,
I never disclosed, but I just wanted to have
it
that
was there, or
clarity in my
it was
mind.
there or not there, my lord. It was there. It was there. In fact, it was there. My lord, it was there in the 18.
It was there. The sentence is that the right of appeal is not against the order rejecting a review, but if the application or the order allowing the review is allowed,
Yes,
then it is assailable on the grounds A, B, C,
specific grounds,
which was deleted and make it more
wider. In fact, my lord, the judgment which my lord Mr. Justice Bhattacharya was pleased to.
Those judgment were when unamended provisions were.
In fact, in 1868, this provision was there.
I just don't know. I have that book.
It has to be, my lord. Has to be.
In my residence library, I have that 1880.
And little more dust free, man.
No, it's kept in a very immaculate.
And that is what I'm saying. Dust free.
Dust free.
কি করবে কবে করতে চাইছো
জবে যাচ্ছে না বলবে না
Yes.
madam I will continue then my lord your lordship yes madam then my lord may I take your lordship
Madan Lal.
Madan Das your lordship will kindly take note of paragraph 29 well, I do not know এটা কি আইআর দিয়েছে না কি দিয়েছে
SCC online has been given.
paragraphs are same দেখে নিয়ে
Anyhow, you just tell me paragraph begins with
my lord paragraph begins with Madan Das
as in the body of the court.
Madam, may I just kindly give me 1 second,
No,
madam?
no, from your book, from your.
all these matters.
No, paragraph 29 I am referring to. No, একটা second. Madan Das টা দেখি। Yes, madam. Thus neither. Thus neither.
Yes, that is paragraph 27.
27. I'm sorry, my lord. My lord, then I have to rework it. Then, my lord, Madan Das. Paragraph 27 it would be then. Then, my lord, may I just read out the proposition which was laid down, the law which was laid down rather. Neither the legislature nor this court in excess of its rulemaking power for regulating its own procedure has deviated from that. This was all about Order 47, Rule 5. Where would the appeals lie? Of Order 47, Rule 5 of the code, and on the other hand has explicitly adopted provisions of Order 47, Rule 5 of the code. Then this is paragraph 27 of the SCC online. Then, my lord, I believe it will be paragraph 35 of SCC online, subject to correction.
This is the 7-judge bench.
Yes, these are 7 judges. These are 7 judges.
So what is it?
Ah,
It doesn't consider Kimji. Kimji is not considered over there.
but the question is what Kimji considered.
Yes. Well, may I
What
take your,
Kimji considered and in what perspective that observation was made.
well, may I take your lordship's leave, madam? Next week.
My lord, then, my lord, paragraph 35. দাঁড়া এক second. This court has specifically adopted it. No. আমার প্যারা 37 এখানে। Yes, yes, paragraph 35. Specifically adopted the provisions of Order 47 Rule 5. Now, these are the two paragraphs I would be relying on,
Paragraph
27 and 35.
So there will be a lot of questions on paragraph 29 and 30.
Yes. Then, my lord, I would be relying on this judgment rendered by, my lord, the 3-judge bench of our High Court in Masammat Raghu Bibi. My lord, this is nothing, this is not nothing to our credit, my lord. This is Justice Bhattacharya's, my lord's mind. So, my lord, this is what I'm referring to. Kindly take, my lord, this is relevant, so relevant even today. My lord, kindly take paragraph page 16 of my compilation.
Justice Peacock, CJ.
Yes, Justice Peacock, CJ. May I just read short judgment? May I just read out? In this case, an application was made to Justice Locke and Mr. Justice Dwarkanath Mitter to review a judgment which they had passed. Mr. Justice Dwarkanath Mitter thought that the review ought to be granted. Mr. Justice Locke, who was the senior judge, thought that the application ought to be rejected, and it was rejected. From this decision, no appeal has been preferred under clause section 15 of the latest
An
patent.
appeal has been preferred,
Yes.
not no appeal. An appeal has been preferred.
An appeal. I'm sorry. An appeal has been preferred under section 15 of the latest patent. Preliminary objection is that this is not a case in which and no appeal lies. An appeal lies. This is. Wow. There is no doubt that the preliminary objection ought to prevail. The whole object of the provisions of Act of 1859 regarding reviews of the judgment is that the court which passed the decree may reconsider the case if it thinks fit, and that as a general rule, the judges are not to review a decision of either other judges. Section 378 is relevant, my lord. Section 378 declares that the order whether for rejecting application or granting the review shall be final. It appears to me that the order rejecting, at that stage no appeal would lie against an order. It appears to me that order rejecting the review was not a function which could be performed by the High Court generally, but merely by the court which passed the original decision, and that the order rejecting a review is not a judgment within the meaning of section 15 of the latest patent. I do not think that the High Court at Madras intended to give any opinion to the effect that an order rejecting a review was a judgment within section 15 of latest patent, although in the case cited they expressed their opinion in general terms which might possibly embrace such a case. If they had the question of rejecting a review before their minds when they decided their case, they would probably have accepted it from the general rule which they laid down. Kindly, my lord, I beseech your lordship, my lord, kindly come back. I'm sorry. Well, may I just? I was just pointing out, my lord will again come back to the first sentence of this page 17, new sentence. It appears to me that the order rejecting the review was not a function which could be performed by the High Court generally, but merely by the court which passed the original decision. This is in sync with Order 47 Rule 5 concept. This is in sync with the law laid down in Madan Das, because it has to go back to that bench. But this is my reading, this is my humble understanding.
Visualize the situations.
Yes.
That's true, because a person who
Authored the judgment.
The
best judge is the best person to decide.
person to say when there is any error, there
Yes,
is any
yes.
mistake or something of that fact. So that is why the object of Order 47 Rule 5 originates.
Right.
It says that as far as practicable, it should be heard by the same judge.
Absolutely, madam.
But there may be a situation where
Transfer, my lord, transfer, retirement, etc. Other unforeseen circumstances.
the God.
Yes, act of God, my lord.
There is that event, there is no fetter on the part of any other judge to decide an application.
Yes,
for
yes,
review.
yes.
This 7-judge bench was for the reason that there was already an amendment having brought by our High Court.
Right.
Appellate side rules concerning the Andaman and Nicobar.
Right. Absolutely, my lord.
So the High Court means the full court,
Right.
full complement of judges, they decided that so far as the Andamans are concerned, whoever will go there will be given an opportunity to deal with that. There was no idea at that point of time about this virtual mode, the technology or something of that kind. In those era.
Absolutely, madam. Nobody thought of that.
Technology really, the computer, I would say, subject to correction. Our country really receives in 1991-92.
Right.
Before that, there was nothing.
There was nothing, my lord.
So that point of time, nobody thought of that. Suppose a person who is living away from the mainland have to travel and then file a review and then same judge at the principal seat. Then it was thought of. then question arose whether this is the correct one. This 7 judges bench was constituted. There they held, in one paragraph they said correctly that so far as the section 122 of the Code of Civil Procedure is concerned, and the other provisions, High Court is within its power to do it. It
Right.
can alter, it can annul the schedule of the Code of Civil Procedure, but not the body of
Body
the
of
court. What is considered to be the body of the court is the substantive provisions like a sections creating or establishing a right.
Right.
That's why the preamble says is a consolidation and amendment of. So consolidated law and amending the law, both amend. And 122 emanates from the body of the court. If that power is given, you can annul, you can alter the schedule. Order 47 comes under the schedule.
Right. Absolutely, my lord.
Yes. Madan Lal says inflexible.
Well, I was just citing I was thought when I was reading this, I thought that this is the spirit or the philosophy behind this order. Somehow, my lord, finds its place in that Madan Lal judge, because it speaks about reinforcement of.
Now it is good because now we have.
No, now everything is.
Virtual one. So.
Now it is easy, my lord. Now it is easy. Now it is very easy.
At that point of time, it was not.
It was very difficult.
This was delivered, it was not a virtual.
No. My lord, virtual we saw only during the COVID times. But virtual, my lord, is a revolution, my lord. Definitely.
Virtual ছিল না virtual তো এই কোভিড এর সময় virtual introduced.
But my lord, one thing, if I am not wrong, there was some via video conference matters which were going on prior to COVID.
I think after this judgment,
I think, my lord, perhaps your lordship used to sit in that video conference room or something like that. There is one room, or the conference room.
No, I correct myself. Yes, it was after this
For Andaman matters. For Andaman matters.
For Andaman matters.
We used to read the list via video conference.
Bad link. Because Andaman, they had a very bad connection at that point of time.
Network is not that good.
The internet speed was not there.
Yeah.
But now it has, because beneath the sea, the line is laid.
Well, the first.
Straight away to there.
Well, the first desktop which I bought in 2001, it had a hard disk drive of, I believe, 16 GB.
GB?
Yes.
Some MB.
16 MB. I'm sorry, 16 MB. 16 MB. And we had that floppy disk drives of 1.44.
When you are late, when I bought the first one, it was a DOS-based computer.
No, we didn't have, we had that Windows 1998. Windows 1998. 97, then prior to that 4.1.1.
Was the DOS-based one.
DOS-based. Yeah. Very difficult to operate, man. Very difficult.
Operating software did not come.
So, Mala, this is.
Generations may be amazed by those facts.
It was very difficult, Mala.
They are born in the computer age.
So, Mala, this is the judgment which I was relying on. Now, if we take, Mala, I believe Mala learned Advocate General had already cited. But prior to that, Mala, AIR 1954 Madras 642. Which I believe is in the compilation itself.
There. There, page 18. There, yeah, we got it. Channa Durai. Order dismissing review, no appeal lies.
Yes. May I
This
just,
is, Chief Justice Rajamanna.
Rajamanna.
But again, a 1-2 paragraph just quoting the order 47 rule 7.
Yes, yes. They referred to my lord full bench of Madras only.
This Muthuswamy Iyer.
Yes, yes.
No, sorry, this is this.
It was held by bench of this court. But yes, Muthu, your lordship is absolutely correct, my lord.
The name of the judge.
It is my lord Acharya versus Ratnavel.
Ratnavel.
Acharya versus Ratnavel, 9 Madras 253. Bench of this court, follow, yes, cross controlled by 629.
And then Babulal Khimji, you have also relied upon which portion?
My lord Babulal Khimji I have kept because I know this was going to be cited. Because I know this was going to be cited, so
there is no other judge.
that is important, my lord. Ram Sahu I have kept. Kindly take the Madras High Court judgment, which is there. Justice, my lord, Mr. Justice Banerjee's judgment as his lordship. His lordship was the then Chief Justice of the Madras High Court. Kindly take, my lord, this 2021. Yes. This was cited by Learned Advocate General on day 1, subject to correction. এটাই তো দেখিয়েছিল। Now, my lord, kindly, this is one very important thing, which I will look. Kindly take paragraph 60 of the judgment. 60. Before I take your lordship to other paragraphs.
Must not be like lost sight of.
Yes. It must not be lost sight of that even order 47 rule 1 of the court has a residuary ground in its use of the expression or for any other sufficient reason. Since the object of the exercise is to prevent a miscarriage of justice, the provisions are left open-ended. This is where, my lord, I join issue, my lord. And I would make my respectful submissions relying on a Supreme Court judgment that these observations which form the backbone of this judgment, these observations are incorrect. Having regard to the law laid down by Supreme Court in Ram Sahu.
Difficulty is that it again left the question because it says that even in such a situation when the order of refusal is there, if the order amounts to.
Malay, if your lordship kindly. Yes, Malay, may I just take your lordship? Malay, order 47, when we read order 47 rule 7, subject to your lordship's kind consideration, when I argue a civil matter with your lordship, it's a, Malay, your lordship knows what kind of butterflies in stomach and all that happen. So, Malay, so it's a difficult scenario. I don't know what right now I'm submitting, whether I'm submitting correctly or not. So, my lord, one must, subject to your lordship's kind consideration, one must bear in mind order 47 rule 8. Why, my lord, in my most respectful submission, my lord, Mr. Justice Banerjee, as his lordship then was, speaking for the bench, referred to 2 stages of order 47 rule 8. One at the stage of entertaining and another at the stage of granting. To the best of my understanding, my lord, if a review petition is not entertained, then entertained at the threshold that no, I did not, this review is not maintainable, then obviously, my lord, no appeal lies. It's at stage 1, according to Madras High Court, which is again based on this perception. Madras High Court confines itself to stage 2. That where there is a decision. But interestingly, subject to correction by my learned friend.
How can it be? Suppose the petition also contains a finding.
Yes, my lord. Kindly take, my lord, what Madras High Court has done. So, just 1 minute, my lord, for your lordship's kind consideration. Paragraph 61.2, Madras High Court. Madras High Court is
Very clear because he has cited this on this ground that Article 226 also.
even if the original order is retained, once the review is entertained, entertained is the stage 1 of Order 47 Rule 8. But if we read Order 47 Rule 8, whatever I could find upon reading Order 47 Rule 8, there are 2 stages. This pertains to stage 1, entertained, after being entertained. Upon being entertained, if there is a decision rejecting the review on merits, it may so happen, my lord, rejecting the review on merits, then it is the view of the 3 judges bench or the full bench of Madras High Court, clause 15, appeal would lie. But, my lord, stage 1, when it is not entertained, then, my lord, this judgment is not an authority for the proposition that even if it is not entertained, then also an appeal would lie under a clause 15 latest patent. Because, my lord, whatever I could read, Order 47 Rule 8 has 2 compartments. Applying this ratio, my lord, generally, my lord, where there is a clear decision of the court which has decided the review petition arising of its own order, that no, I will not going to entertain for XYZ reason, then in that event, well, even if we apply this Madras High Court judgment, the clause 15 latest patent is not maintainable. Happy. Well, this is what I could gather. Well, this is kindly, well, bear with me once, well, bear with me. Kindly take my lord for once.
47.
Yes. এটা কোথায় আছে দাঁড়া। But if lordship kindly takes it is registry, it has to be registered. Then if it is registered, a note thereof shall be made in the register, and the court may at once hear the case or make such order in regard to rehearing as it thinks fit. But my lord, when it is not entertained at all, I put the question to myself with all humility, whether even if we apply this judgment, whether it review clause 15 appeal is maintainable or not.
The distinction, you know, the distinction is that there are three concepts.
Right.
First concept is before the entertainment,
Right.
or entertainable.
Right.
Is the maintainability.
Right.
First thing is whether
Maintainability. Yes.
Maintainable.
Maintainable.
The moment one crosses the hurdle of maintainability, then second is whether it is entertainable.
Right.
Then the third one it crosses, then whether it should be allowed.
Allowed.
Now the question is, if it is not maintainable, then it is not a decision on merit. Simply saying that this application is barred.
Maybe not in form, etc., etc. It's
whatever. But once it is entertained,
right,
then a decision is taken whether it should be allowed or it should not be allowed. In both the cases, it is a bounden duty of the court to record a reasons.
Right.
Affecting the rights.
Right.
The question is, if it has to come within the folds of the word judgment,
right,
appearing under clause 15 of the latest patent, then one has to understand whether this order, which is otherwise not amenable to be assailed by way of appeal under order 43,
right,
but has affected the rights in some way or another. The right to have the review of an order is affected by rejection thereof. If it is the judgment, then why not the Kimji will come into play and say that yes, it is.
My lord, my respectful submission so far as Kimji is concerned, my lord, that is
why there is a judgment of, I think, this court itself, Justice A.M. Bhattacharya.
Yes.
In relation to a Hindu Marriage Act.
Right.
Where you will find under section 12 or 13, there is an embargo of 1 year in presenting an application for divorce.
Right. Absolutely. Right.
The word which was used is that the application for dissolution of marriage shall not be entertained unless there is a marriage of at least 1 year they have.
No, that period has to be over.
So the question then arose that what is the meaning of the word entertain? Can it be interpreted as a synonym of maintain? Justice Bhattacharya made a distinction that the application will come. It is maintainable. Filing you cannot deny. Very interesting judgment. Filing you cannot deny. It will be there, but the court will not touch upon that application. Means will not entertain. It's entertain means touching upon or putting an effort or putting a mind into the cause. Filing is not a bar.
Filing is not a bar.
Mean to a maintainable, but entertain the court will not pass any order before 1 year.
My lord,
That is what the concept of entertainability.
absolutely, my lord. Then, my lord, 61.2 is a wrong perception. Then 61.2 goes.
Has to be in view of the Supreme Court judgment. These are of maybe of a different court persuasive value. But if we have a judgment of the Supreme Court, then we'll have to consider.
No, your lordship will definitely consider the Supreme Court judgment, but kindly consider the Supreme Court judgment in the light of what formed the basis of that particular observation.
Here, there are some gray area.
This is the gray area, my lord, which, my lord, if gray areas are not crossed, my lord.
Was it warranted by the Supreme Court?
My lord, gray areas are just like tunnels, my lord. My lord, we can only see the light at the end of the tunnel.
In that King's judgment, it is not the honorable judges who thought of saying, it is the appearing counsel who invited the attention of the honorable judges to decide it, when it was not necessary at all.
Then, my lord, it is not part of the, my lord, the ratio of the judgment. Absolutely.
Arbiter is also
binding. I know that, my lord. Supreme Court arbiter is binding. But, my lord, your lordship will decide. Your lordship will decide in this case the basis of those observations and to what extent these observations would be binding so far as a rejection, the order rejecting review under order for.
Very sound logic which is given everywhere. You have to consider it that perspective.
That perspective, your lordship.
That observation of.
So, my lord, so far as the Madras High Court judgment is concerned, my lord, I am grateful to your lordship. But I could not have expressed in a better way. Under no circumstance I could have done so. So, my lord, this judgment, my lord, is not, perhaps not the correct law. Perhaps not the correct law. And, my lord, it also proceeds on the basis that any other sufficient reason my lord, would be an open-ended. That is incorrect having regard to Ram Sahu. But I will just give the paragraph of Ram Sahu. Ram Sahu, paragraph 7.3 and 8. 2021 13 SCC, page 1, paragraph 7.38. It's all about the and 8. না এটা কি হলো এটা কি রাম সাহু তো না এক সেকেন্ড সাবজেক্ট অপোজিট মিশন on the mission এটা তো 8 must be conferred either by person Devi 9 in second. One paragraph. Just 1 minute. Then. তো এখানে গোলমাল হয়ে গেছে না 7.2 and 7.3. I'm sorry. 7.2 and 7.3. Re-hearing not review is the act of looking in the occasion and self and other. No ground for review. The court disposal of the case. Then could be not be produced 7.2 হচ্ছে unspecified. More restricted than our paragraph 10. No, 7.1. Lily Thomas referred. Paragraph 10, 10 and 11. Observation also just a minute. Restricted. Yes. The words any other sufficient reasons appearing in order 47 rule 1 CPC must, I'm sorry, 7.2 তে দেখতে এটা আছে or 7.1 7.21 এক সেকেন্ড দাঁড়া বলছি yes right 7.2 তে আছে 7.2
Which one?
Malad, this is Shriram Sahu, paragraph 7.2. This is page, starts at page 1. Na? Page 1, Malad, I take your lordship directly to page 21 and 22 pages. 7.2 starts at page 21, following Lily Thomas.
Yes.
Malad, this in Lily Thomas. Malad, 7.2 paragraph page 21. 7.2 the last at the bottom of paragraph page 21. In Lily Thomas it observed and held that the power of review can be exercised for correction of a mistake but not to substitute a view. Such powers can be exercised within the limits of the statute dealing with the exercise of the power. It is further observed in the said decision that the words any other sufficient reason appearing in order 47 rule 1 CPC must mean a reason sufficient on grounds at least.
This is the best example for that. For any other sufficient reasons it is recorded. Sajuran has said must be relatable to the specified.
Yes. So that observation made in paragraph 60, which I read, it said not the correct position of law of the Madras High Court judgment. My lord, will kindly give me one more day, 15-20 minutes. If I can find something more, I will come back to your lordship. 10-15 minutes more.
The review, the power of review, there are section of judgment.
That is, it's not an appeal in disguise.
One of the landmark judgment on this is Tungabhadra.
Tungabhadra 64 Supreme Court, my lord.
in 16442 or something. Tungabhadra, then Ashok Rupa Hura is very
Rupa Ashok Hurra versus
same.
husband wife.
So this is where the review, this jurisdiction has been expanded. Question is not that when can a court exercise the review jurisdiction?
Question is that whether an appeal will lie.
We were having an impression, to be very clear, don't take it as our final opinion on that.
Yes.
It's only a question of discussions that what was the occasion for the legislature to incorporate Order 47 Rule 7. But I've seen the earlier one also. In the earlier one also, it was in the sub rule 1. It was said that the no appeal shall lie against an order rejecting the review. That was there.
The quietest theory, as fell from my lord. It is the quietest theory.
When you talk about this, the question was that why it was so thought of, because if you grant the review, then the existence of a parent order goes. It's the review order which remains. If you reject the review application, the existence of the parent order remains. But rejection of the review will not tantamount to merger of a parent order into a review order.
Right.
So that order would remain executable, not the order of the review.
Right. Absolutely.
And even after rejecting the review, the right to file an appeal against the parent order remains. So that was a concept that since it does not impact either the parent's order or something, it should not be made applicable. This was what
my second line of judgments is that 3 judgments where, my lord, the terminal theory has been applied. Terminal theory. We come back on and I didn't expect that my turn would come today. So, my lord, whatever I could get myself ready, I will come back. I will not take more than 10-15 minutes.
But again, I am saying now the trend of these judgments, which has originated, and I tell you very frankly, as you know, my
No, my lord, it's absolutely. No, your lordship expresses your lordship's mind. It doesn't matter. My lord,
that at least you must have.
I understand. Yes, certainly, sir. Certainly, my lord, certainly.
The Kinji is creating a problem, that observation.
That observation, my lord. The key word used by your lordship is observation. Yes. When I read that paragraph, in Kimji,
consciously use it. Is it mere passing observation?
My lord, I will borrow your lordship's observation that when you find something, go to the root of the matter. So I tried to go to the root of the matter by reading 63. I found that it is entirely different.
Mr. Mujumdar, even if it is the arbiter of the Supreme Court that is binding.
It may be an arbiter, my lord. Your lordship will certainly look at the judgment.
When can an arbiter does not bind?
Yeah.
When there was nothing on record, nothing was argued, and out of some context.
Out of context, passing remark, passing observation.
You cannot. Here, one of the counsel argues this point, invited the attention of the judges that look, this is the judgment, Vijay Kumar, it is there, this principles is there.
I never thought that, my lord, 44 years later, my lord, we would be facing the problem.
So this was argued that if the court has decided a point which has been argued, then you can't say it an arbiter.
It's a question.
May not be relevant, but not an arbiter. Simplicity.
May not be relevant, my lord.
May not be relevant, but not an arbiter in that.
But, my lord, I tried in my home humble way that, my lord, this is not what was decided. It was a statutory rule. And questions were left open as pointed out by your lordship. Well, we will come back. Well, I will try to assist your lordship. Whatever happens, my lord.
It is me who has invited this problem. Me who have raised this point.
But this is a crucial issue, my lord. This is a crucial issue. Well, there will be, this is like, my lord, just 2 minutes of your lordship's time. when we used to read the children's stories, your lordship may have read Shivram Chakraborty, right, my lord? There was one story where, my lord, Govardhan, Harshavardhan's brother, he was taught to run to catch thief. My lord, he started running, he took training, he started running.